Good day, everybody. Welcome to the Entheogenic Esquire podcast. My name is Greg Lake. I'm a trial and appellate attorney specializing in civil rights and nonprofit law and formation. Today's episode is going to be an introductory video that will be part of a 6-video series that I have planned. We're going to be exploring the prospects of Tyler Robinson's legal defense. And for those who are probably or could be unaware of who the hell is Tyler Robinson and what's this legal defense, Tyler Robinson is the individual who is accused of unaliving Charlie Kirk, the famous conservative commentator, in September of last year. He's currently being held in Utah on charges of first-degree murder, amongst others, and currently is being incarcerated based upon an information filed by the local prosecutor that is alleging that Tyler, with a .30-06, caused the untimely death of Charlie Kirk by placing a bullet into Charlie Kirk's neck. Let me apologize real quick. We do have a podcast studio construction underway downstairs, and so you might hear some construction noises. Please disregard them. Hopefully we'll be down there broadcasting before too awful long. So just wanted to make everyone aware of that. So back to where I was at. So again, we're going to be examining Tyler Robinson's legal defense, and specifically as it relates to mounting a challenge against the current information on file with the local district court there in Utah. So as many are aware, there's been a lot of independent investigation going on with Candace Owens, Baron Coleman, Coach Colin. There's a lot of YouTube accounts, Ian Carroll, a lot of YouTube accounts right now that have been really looking deeply into this. Trigger Smart as well. Don't let me forget Trigger Smart, because through these online creators, and particularly with Trigger Smart, there has been some, in my opinion, as a trial lawyer, some very credible experts that have come out, ballistics experts, other experts who've taken a look at this case, and particularly the video of, the unfortunate video, which we're not going to play here, but I'm sure most have seen the video showing Charlie Kirk being unalived on that fateful day in September. But expert analysis of that video and other facets and pieces of evidence which have been made available to the public seems to draw into serious question whether in fact it was even a gunshot that caused Charlie Kirk's death on that fateful day. And so, again, this video series is going to be taking a look at the procedural rules in Utah that allow for a challenge to an information, the rules of evidence in Utah that allow for expert testimony, and other aspects of the legal environment there in Utah, all bearing upon or affecting a challenge to the current information on file against Tyler Robinson. So I've taken a preliminary look at, obviously, the Utah Rules of Criminal Procedure, evidence, stuff like that. Everything to date has pretty much checked out as far as this being a valid avenue to challenge the information currently on file. And again, this challenge would be limited to, I want to make this clear too, is that there are expert theories out there as to alternate causes of death. There are maybe not necessarily expert theories, but other theories about if not Tyler Robinson acting in a sole capacity, who else could be involved, or if Tyler Robinson wasn't involved, who actually caused the untimely demise of Charlie Kirk. So again, this video series will really just be focusing on the evidence in support or not supporting the cause of death as alleged in the information, which is that Tyler Robinson shot Charlie Kirk through the neck with a .30-06 rifle. Okay, and I'm sure lots of people who are watching this video have probably seen a lot of these other videos and a lot of other creators and experts who have been pretty consistently coming out with new theories, new information, new analysis, and I've just kind of been sitting back and soaking it all up taking notes, doing further research investigation, and have been working on compiling all that for this video series. And so I'm very anxious and very happy and honored to bring that to you, because I think ultimately, one, this will be a great way for me to really practice or put in or implement what I built this channel for, which one of the primary reasons I built this channel is to educate the public on law, civil rights, constitutional law, things of that nature. But two, one thing I want to say too is that this challenge, and we'll get into this in more detail in later videos, but this challenge theoretically would cause the state to produce evidence that is currently not in the public record if they want to show up and defend their 30-06 bullet in the neck narrative. Well, they're going to have to produce some evidence, particularly like an autopsy report, the doctor who did the autopsy, evidence that's currently not in the public record. And so again, there's incidental benefits here beyond potentially freeing Tyler Robinson, or at the very least dramatically reducing his charges. This challenge could also have the incidental effect of causing the state to produce evidence which is currently not in the public record, but which evidence many people out here in the public, particularly content creators and experts, have adamantly been calling for. And quite frankly, it's not a stretch to say, well, it's not a stretch at all. From my perspective, public opinion is not very good right now as far as government, public trust in the government and in this investigative process. And so if the state is really sold on its theory, this would be a great opportunity for it to come out and produce the evidence needed to actually substantiate that theory. Because right now, with the expert analysis and tests which have been conducted, it's not looking too hot for the 30-06 bullet to the neck theory. So again, and we'll sort this out, within this video series in much finer detail, but just wanted to kind of give the lay of the land here. Now, one thing I wanted to do real quick in this video is discuss, I know people have probably been picking up on the fact that I've been saying the word information, okay? And so there goes Barron right there. I've got a quick clip I'm going to play in a second. But before that, I want to real quick go into what is an information, what is an indictment? Because right now, the document that on file in the district court that it's responsible for Tyler Robinson's incarceration is an information, which is different from an indictment. And so what I've done here is actually ran with my ChatGPT. So just so you know, I use ChatGPT quite a bit, even in some of my legal work, not for research per se, but I do use it. I've written several books and I've uploaded them into my GPT. It knows kind of my style of writing and thinking and stuff like that. So I don't lean heavily on ChatGPT, particularly in the legal realm per se, but I did use ChatGPT here just to do a quick breakdown of what is the difference between an information and an indictment, because it's going to be material here in terms of assessing the prospects of a successful challenge to the current information on file. So let's just take a look real quick. We're not going to spend a bunch of time on this, but I just want to talk briefly about those differences because they matter. So here, we see here, indictment, probable cause found by a grand jury. So that's kind of the main difference here, ladies and gentlemen, is that an indictment is when the prosecutor calls a grand jury of a community. Again, the size varies, stuff like that. But I think everybody has a pretty good feeling for what an indictment is, right? A grand jury comes, it's a very one-sided thing. The prosecutor presents the evidence, lays out the potential charges, and the grand jury votes yay or nay, and then that serves as the basis for, perhaps a later arrest warrant, imprisoning the person waiting upon trial. Now, an information is different, right? Here it says probable cause asserted by a prosecutor and reviewed sometime later by a judge. And so that's what we have here. The prosecutor went and filled out, and we're going to, in the next episode, actually, we're going to go over that information specifically, and we're going to take a look at the allegations in there. But essentially, the prosecutor here received evidence from the detectives and other investigators very early on receive that evidence, and then in an affidavit puts all that together, states what charges are justified or that they're bringing based upon the facts that the investigation has allegedly revealed. And so again, overall, the difference: grand jury with an indictment, simply the prosecutor, right? In this instance, in an information. And so, as you could imagine, an indictment is a little bit harder to challenge as far as it's more solid in because when you're imprisoned or you're taken into custody, obviously your civil rights are being violated, right? So like the standard upon which that can occur is pretty important. So as we see, in theory, it's going to be much more difficult, but much more solid if you have and not like a grand jury indictment's hard to acquire, but in terms of a prosecutor filling out an affidavit versus a grand jury indictment, obviously there's a difference there because the information is much easier and doesn't require third parties from the community chiming in on it. It lends itself to being challenged much easier. It's not as strong of a basis to keep someone in custody as an indictment is, even though an indictment can also be challenged as well. But here, we'll talk about the indictment for a second. It says the charging document after a grand jury votes that probable cause exists. Its key features, according to GPT, is that's initiated by a prosecutor, but it's decided by a grand jury. The proceedings are secret. The defense has no right to participate. The evidence rules are relaxed, and as we'll see, they also are at these preliminary hearings challenging it as well, perhaps not as much as a grand jury. But it says no obligation to present exculpatory evidence. And so let's just say, for instance, the prosecutor today went to go and get an indictment against Tyler Robinson. Perhaps they would have a duty. I take that back. They wouldn't have a duty, apologize, I got mixed up there, to present the expert evidence and test and stuff like that we're going to be talking about in this video series. And certainly at the time they did the information, in this case, to best of my knowledge, none of this was really available. No one, I don't think at the time, had really started to dig into that conversation quite yet. Practical reality, it says a grand jury is a one-sided room. The prosecutor presents what they want, how they want, and leaves the court with what they came for most of the time. And that's true. It's very rare a prosecutor isn't able to acquire a grand jury indictment. Here goes the information. So this is the prosecutorial filing route. This is currently the document that is causing Tyler Robinson to be held in custody. And here it says an information is a charging document filed directly by the prosecutor, asserting that probable cause exists. And here goes the key features according to ChatGPT. It's filed without a grand jury, based on police reports, affidavits, and investigative summaries. We'll see that was largely what occurred here in Tyler Robinson's case. Subject to judicial scrutiny. So absolutely, and that's what we're going to be talking about in this video series. More vulnerable to challenge, obviously. And can trigger probable cause hearing and disclosure pressure, right? So that disclosure pressure really is mentioning or referencing what I was just talking about with as far as the state will probably, if there is a challenge and the state is up to the challenge of responding to the challenge, then they're probably going to have to disclose evidence which is currently not in the public record, with the most important and desired one being the autopsy report, okay? If they want to obviously defend their theory that there is a bullet to the neck that unalived Charlie Kirk, the autopsy report is probably going to be critical and actually, I would say, required in order for them to satisfactorily, uphold the information in the information. And then here it goes, Utah's practice, the quiet truth. It says Utah, like many Western states, frequently use information, even in serious felony cases. And why? They're faster, cheaper, less logistically complex, and no grand jury wrangling. But it has a cost, and that is less insulation from challenge, more exposure to being challenged, and greater risk of forced disclosure of evidence that otherwise they would want to keep under wraps pending the trial, right? So again, here that really is going to be talking about the autopsy report, amongst some other things that we'll discuss throughout the course of this video series. So anyways, that's all I wanted to show you there. It's very interesting moving forward whether there will actually be a challenge to this indictment. Just the other night, and I have a clip queued up here. I guess I'll play it in just a second, but here I'm going to queue up a clip because there are some perhaps issues or facts or whatever you want to call it that might mean that there's not a challenge filed, okay? And so what could those be? Well, the first is, I think the top of many people's heads would be some type of massive cover-up, right? Because with the amount, and I'm going to say quality of expert testing and testimony available to the defense here, it would strike me, and I think Barron would agree with this based upon kind of my reading of his comments, that like, it would be very suspicious. It will be very suspicious if Tyler Robinson's defense does not file this challenge. There seems to be an indication that they're not going to challenge the narrative that a gunshot to the neck killed Charlie Kirk. And I say that also based upon one of Barron's live streams. And was it last night? Sorry, y'all. Sometimes I get these things mixed up. And I'll in one of these later episodes, I'll go dig it up and bring it to you. But Barron was going through one of the recent motions that I believe it was the defense motion to disqualify the state's attorney's office because they had a child that was at the event, stuff like that. I'm not going to go into the details there, but Barron was looking through some of these pleadings and was noticing that the state is consistently referencing in these ancillary motions, might I call it, because these motions aren't really addressing the merits or like a probable cause challenge, but kind of these ancillary issues. But still, as a trial lawyer, let me tell you, you got to be careful because the state has obviously been advancing this gunshot narrative in these other motions. And it looks, if I remember correctly, I'll go back and take a second look at the actual pleadings, but I believe Barron, when he was stating that it doesn't look like they're really challenging, which they really need to be, if you ask, in my opinion. For instance, if I'm representing a client in a criminal case like this and the government has this narrative that they're pushing, I don't care if it's in a pleading, if I'm in open court, anytime that they're in there asserting that as cold hard fact, I'm going to make sure that there's a challenge to it. And it looks like so far Tyler Robinson's defense team hasn't really been doing the job that they should. And so that kind of does relate back and speak to, in my opinion anyways, whether they're going to be filing a challenge to the information to the cause of death. And perhaps if they're not already challenging these things, ladies and gentlemen, they very well might not be. And so again, what does that say? Without going into any wild speculation here, it seems to indicate that there very well might be a cover-up. I mean, I think it's fair to say, at least again in my opinion, that if Tyler Robinson's legal defense does not challenge the manner or cause of death, all other things being equal, it very well, could mean ineffective assistance to counsel, perhaps a malpractice case against the attorney, just because the evidence throwing serious doubt, raising serious questions on that narrative is out there in the public record. And so this goes into my next point. I want to say I heard John Bray and the other gentleman who has the West Texas is the Best Texas YouTube channel. I apologize, man. I can't remember your name off the top of my head. I will reference him because he did a great... He's been going through all the videos and looking at all of them. But anyways, both of these individuals related in their content that they've actually reached out to Tyler Robinson's defense to bring these matters to their attention and have gotten no response. Okay? When I heard that, it's the prospects, likelihood of them mounting this challenge. I mean, look, The preliminary hearing is set for May, so that would be the proceeding where this challenge would be lodged. Okay, and that's already set for May. So granted, there's time, and as a trial lawyer, I tell you, there's still plenty of time for them to get it together, to get these experts, to get everything done that they need to then file and show up and lodge an appropriate challenge to this. So the fact that in the last few weeks they've been reached out to and haven't contacted these people, back, definitely doesn't mean open and shut that they're not going to mount a challenge to the information. But God, the prospects look kind of bleak, unfortunately. That's what that signals to me. So let's just hope and pray that that's not the case. Let's just hope and pray that they're just getting all their ducks in a row before they decide to reach out and start really putting all these pieces together. I will admit, and I have to say as a trial lawyer, that working with experts, presenting expert testimony, things of this nature are not easy. I just got done presenting expert testimony in a 3-series evidentiary hearing in federal court in a criminal case. We wrapped up the proceedings about a month or so ago. So I've recently gone through this of presenting expert testimony. So, it's not easy. It's a lot of work. Wrangling experts, getting opinions, putting it all together, solid presentation. Yeah, it's onerous for sure. And it takes some time. So they're going to need to probably get on the ball here sooner rather than later if they really want to get it together and have the best possible presentation or challenge. But again, something tells me that they just might not be asserting a challenge to this. And so but regardless, we're going to go through it and we're going to talk about, in my opinion, at least what should be done, what could be done, and whatever that looks like at the end of this. Hopefully that'll help inform everybody that's listening to this about the true nature of this whole thing, and especially the legal proceedings currently underway in Utah against Tyler Robinson. So I hope that. Now, the last thing I want to share, the potential roadblock to this challenge being effectively lodged is, and I'm about to play a clip real quick from Ian and Barron's live stream the other night, but the prospect of what if Tyler Robinson, even though he wasn't the person who ended the life of Charlie Kirk, but what if he is a willing participant in the larger conspiracy or cover-up of who truly was potentially who truly was responsible for this. And so let me switch over real quick and play this for you. Just because they raise it really well, and I'm just a really big fan of these two, so I just wanted to play them talking about it real quick, and just to kind of highlight that might be an issue.
And how he was smiling and laughing, and there's this fake lip reading that's totally not Fetterman's about how he said that he was so happy that he did it, and it's like, okay, so a huge question in my mind that I think we should all be asking is, was Tyler Robinson duped into being a patsy, or is Tyler Robinson a willing patsy, right? Because that is a very different trial that we're about to see, depending on the two. And since you have experience with trials, Barron, I want to hear your take on.
Well, I was going to say, if he is a willing patsy, I don't know that you'll get a trial.
Mm-hmm.
If he's a duped patsy, he might think, I feel like Lee Harvey Oswald was a duped patsy.
I agree.
Because Lee Harvey Oswald, what were some of his final words? I'm a patsy. I didn't do it.
I'm a patsy. I didn't shoot anyone.
And then Jack Ruby takes him down. Man, have you ever gone deep on the Jack Ruby train?
Oh, yeah.
Yeah. You know who I want to interview is, the problem is I can't keep it to one subject because he's so knowledgeable. I'd love to interview Roger Stone on JFK.
Oh, yeah.
And I feel like I could get him on. Like, I've got a good friend of mine who's a very good friend of his. I would love to get him to go deep on that. But the Jack Ruby, Lee Harvey Oswald scenario, I don't feel like that dynamic exists here because I don't believe that Tyler Robinson is an unwitting patsy.
I suspect you are correct.
I think
so then the next question is, do you think he was recruited? Do you think that Tyler was recruited, or do you think that Lance was blackmailed or recruited and then Tyler? And obviously this is pure speculation at this point.
Sure.
But do you think it's more likely that Tyler was the recruited one that brought these guys?
So I will end it there. But again, just wanted to play that little bit because, this issue of whether Tyler was a willing Patsy could very much affect whether there's going to be a challenge to it, right? Because if he willingly was part of this, and again, this is not, it's speculation, but I'm not really speculating. I'm just kind of, again, reviewing what Ian and Barron were bringing up, and it's just the prospect, just the hypothetical, if Tyler Robinson willingly participated in this event, but was not the one to pull a trigger to cause the untimely demise of Charlie Kirk, would he then even file or challenge this information? Okay, maybe this has all been planned out prior. Okay, I guess that's where I'm going to end at. Not saying it was. I sure hope it wasn't. But we have to face that prospect whenever we're discussing the potential or likelihood that his legal defense team is going to mount a challenge to the information currently on file. So that's that. Before we leave off, I want to just go through and state kind of the roadmap for this conversation that I'm going to be going in. But obviously we have now this intro video. Next video, we're going to go into the allegations contained in the information. And so that way we get a really solid idea of exactly what is being alleged against Tyler Robinson, right? Because that's going to be a necessary prerequisite for us to effectively assess both the probability and likelihood of success of a challenge to the information. Next, we're going to go review the videos and other content of these experts, for instance, conducting ballistic tests. Videos with John. I have a video of John Bray talking about the video coding that he did, and then looking at that video and how it, basically indicated to him that there's no way that a bullet could have been responsible for the wound on Charlie Kirk's neck. And there are a few other tidbits, right, that will bear upon this question of whether a bullet wound to the neck is actually what caused Charlie Kirk's death. So we're going to do a whole episode of that. And within that expert episode, we'll also be talking about the rules of evidence and how you get experts admitted and what they can testify to, things of that nature. Now, I'm not going to go really deep because, again, that can be a very difficult subject matter, but I want everyone here to get a basic understanding of that whole process and paradigm, so to speak. From there, we're going to go and we're going to connect the dots, right? So then we're going to kind of look at, okay, what is the procedure? We're going to go from what is in the information, what procedural rules allow for a challenge of that information, what substantive evidence and testimony and other bits of evidence do we have to challenge it. And then we'll go into kind of looking at it and sorting it out a little bit, kind of as if we were the judge. What would they be looking at, and what would perhaps be compelling versus less compelling stuff. Again, not going to completely put myself in the shoes of the judge, right? But just kind of frame it for the viewers to be able to understand what judge would be looking at. And hopefully everyone can make up their own decision off maybe what they would do if they were judge. And perhaps I give my obvious opinion on it at that time. But again, I'm not going to go say this is what judge should do, and but just set it up that way everybody knows what judge would be looking at in that situation. And then lastly, then the next one we're going to discuss, kind of what are the adverse consequences that could flow from a successful challenge. We're going to talk about what bits of evidence, further than what I have today, what bits of evidence might the state have to bring to the table that they haven't currently disclosed. So again, we're going to be looking at what are some of the negative consequences. Now, one other issue that I plan to tackle in that video as well, and Barron mentioned it, at least I think it was last night, but the state, or I take it back, the defense team has apparently lodged a motion to preserve evidence, basically, and it has to do with some biologics. So again, this is a kind of a dense issue that we could get into right now that I'm not going to, but yeah, apparently there's some biologics that could go missing, and so the defense has filed a motion to preserve. And so we're going to talk about duties to preserve evidence, what are the consequences for not preserving evidence, and ultimately I want to go into, is there anything that can be done for the state, the government, failing to preserve the crime scene? There's a doctrine called spoliation. I say it's a doctrine. It's a legal rule called spoliation. And whenever a party has a duty to preserve evidence and they fail to preserve that evidence, certain times the court will tell the jury what we call an adverse inference, basically saying that because this party didn't preserve this evidence it had the duty to preserve, you are to assume that that evidence was not favorable to their case. Now, whether something like that would be warranted here, whether it's on the table, I would just be speculating right now. I definitely need to look further into Utah's rules in those regards, right? Which I will be probably do that over this weekend, one of the things I research. But we're going to talk about that because I know people are upset about the fact that this crime scene was literally paved over. Like Barron said, an actual cover-up occurred, like an actual cover-up. And yeah, it pisses people off, and rightfully so. That's part of my language. That's bullshit. That's bullshit. And it really, comes with it seems to me that they think we're all just stupid, right? Like we wouldn't call into question or find it dubious that a crime scene like 3 days after on a Sunday was paved over, that doesn't indicate to us anything nefarious could be going on there. Okay, so we're going to see if there's a possibility that Tyler Robinson's legal defense could bring something up in court to perhaps punish the state for failing to do what they should have done, and that is to properly preserve that crime scene. So that's going to be part of that episode as well. And again, the last one, and I kind of went into it just a little bit, we're going to discuss the actual prospects of Tyler Robinson's defense team mounting this challenge. And so we just went over a few really quick things that might indicate that they might not lodge that challenge, but I'm going to put together a more comprehensive and pointed analysis and demonstration of those things. And so that way we can, if we're going to speculate, let's speculate with all the best and all the good evidence, right? So I'm going to try to set that up too for that last episode because, at the end of the day, it's like, hey, there can be this great challenge we pointed out, whoop-de-whoop, but what if it doesn't happen? And again, as I stated, if it doesn't happen, not all is lost. That will give us some further indication of if the actual cover-up is an actual cover-up, how deep and wide that may go. And just so we're aware here, everybody, I'm not going to go into speculating on specifically who may or may not have been involved with this, okay? But I sure will speculate if this challenge is not lodged, what that might mean in terms of if there is a cover-up. Man, how deep and wide might this thing go? I might get into a little bit of it, but not to ever identify any person specifically. So just want to let everybody know that. Anyways, I'm looking at my outline here. I think that's about all I have for this initial video on Tyler Robinson mounting the legal defense. I would love and be honored to collaborate with anyone else, any other content creators out there to be honest with y'all, Ian Carroll right now, I think me and him together, him and I, could do a really good presentation in this regard, just because he's got all the facts at hand. But I'd also love to collaborate with Barron, a fellow trial lawyer. If it happens, it happens. If not, I'm still going to be dedicated to bringing y'all the best content possible. And, we'll do my best to make sure that my opinions, and again, my opinions this is not legal advice to anybody. I mean, obviously, we're not talking about anybody's specific legal situation, but just know that I'm not here to give legal opinions or advice, right? So please don't construe it that way. Just using my knowledge and skill set to help the public make sense of this, because look, quite frankly, for many people, It doesn't make any damn sense. And I'm not saying my expertise or these videos are going to, resolve everything for you. But hopefully we can get a little bit better and firmer grasp on exactly what occurred in September 2025. Because for anyone to sit here and tell us they exactly know what this is, I think they're stretching it a little bit. So hopefully I can help y'all. I'm going to end this here. Look, I love everybody. Thank y'all very much. Any support I can get, likes, comments, shares, all of that, subscribe, please, would be very, very helpful. I'm dedicated to doing this 100%. My podcast studio should be up within the month, and we're going to be going full steam. So thank y'all, and thank you for being forgiving. I'm working on it. I'm trying to get good, figure out my format here, all that stuff. And so just thank you from the bottom of my heart for being here with me and for me. And we're all going to be better at the end of all this, I promise. So anyways, much love. Y'all have a great day. Peace.